no, stand submitted. Thank you. Now we'll move into 68769, Greystone, Nevada LLC versus McCoy. Both sides have used up all their time, so, but knowing that you have another case, it doesn't really matter. Plus you went about 3 minutes over, so. Mr. King.
I can reserve 5 minutes.
Good luck.
Thank you. And frankly, I don't anticipate using all my time unless I'm entertaining questions, because these issues, these very same agreements we just discussed a month ago. So these are the exact same provisions. Mr. Shinnick is suggesting that we're doing some artful argument here and trying to interpret the arbitration agreements. Like there's some covert desire to take away Chapter 40 rights. And again, just emphasizing the basic premise that was set out years ago by the United States Supreme Court and this court: arbitrators have to enforce the law. And in this case, the agreements are even more emphasize that appointment, that premise even more emphatically. If we turn to the CC&Rs themselves, as we raised 30 days ago, it says right out in the CC&Rs for this community, the arbitrator shall be authorized to provide all recognized remedies available in law or in equity for any cause of action that is the basis of arbitration. It couldn't be any more clear. There's no artful, creative argument here. It's right there in black and white. Arbitrators have to provide all recognized remedies. It even goes far in 3 provisions down. It says, in talking about the fees and costs, as Justice Pickering mentioned, during normal litigation, parties bear their own fees and costs until the award at the end. This provision says, however, the fees and costs of the arbitration and or the arbitrator ultimately shall be borne as determined by the arbitrator. It's absolutely clear the arbitrator is going to needs to follow the law in awarding those damages under Chapter 40. With regard to the purchase and sale agreement, this applies to 3 of the 11 homes, because 3 of the 11 are original homeowners. It goes on to say that the cost of mediation and arbitration shall be borne equally by the seller and buyer, unless otherwise provided by law. If it didn't have that phrase, unless provided by law, I would still stand here and argue that the arbitrator still has to follow the law and has the ability to award fees and costs pursuant to NRS 40. But this clause, unless otherwise provided by law, emphasizes that fact again. The arbitrator must follow the law.
What if there were a clause in your purchase and sale agreement that said nobody gets attorney's fees or costs even after the conclusion of the arbitration? How would that be analyzed under a motion to compel arbitration?
I believe that provision, barring the recovery of fees and costs, would be an attempt to change the substantive law, and that runs the risk of being substantively unconscionable.
Okay, so you would say that was appropriate to be considered in the substantive unconscionability analysis rather than a determination for the arbitrator to make of whether that provision is illegal.
And I'm assuming there's not a delegation clause within that arbitration provision. If there isn't one, then I believe that is something for if the claimants are arguing that it's unconscionable because of that term, then I believe the trial court can make that determination. And unless you have any other questions, I'm going to sit down.
So is it for the I'm sorry, I have one more question. Is it for the district court judge in assessing arbitration then, in your vision of this, to decide whether there's anything substantively about the arbitration process that is in conflict with substantive law?
I believe that's within the purview of that trial court. And
so what do you do with the case about class actions that, let's say you had Chapter 40 that said there's a right to class action. How would that analyze under FAA law?
Can you give that hypo one more time?
Let's say that you have a statute that says you have a right to a class action in a Chapter 40 proceeding,
Okay.
and that you have an arbitration clause that says there is no class actions in arbitration and you are required to arbitrate. How do you come out under U.S. Supreme Court authority on that?
Wow, that's a great question. If that agreement is procedurally conscionable and it's absolutely clear that you're changing those laws, then you do have a supremacy clause conflict. And I would probably argue that the FAA would control over that state law. As long as the procedural is procedurally conspicuous and conscionable, I'm going to side with the FAA controlling over the state law.
Thank you.
You have 9 minutes and 42 seconds for rebuttal if you need it.
Thank you.
Mr. Shinnick?
Thank you, Your Honor. I think it bears repeating that the public purpose of Chapter 40 is something that should not be contravenable, if you will, by private agreement. That is a public purpose that, and these are maxims of jurisprudence, basically, that talk about if a law is enacted for a public purpose, can it be disregarded by private agreement? The classic is one cannot consent to be the victim of a crime. That is, there are public purposes associated with that, and any agreements that attempt to change that, I think, are frankly suspect. That applies to these, whether they're CC&Rs or they're sales agreements. There should be no mistake about it. Nobody in this room, or nobody reading the decisions, should come to any different conclusion other than that these terms are put in the sales agreement and in the CC&Rs for one reason, to limit the Chapter 40 rights of the homeowners, to make it a more favorable situation for the developer side who created the sales agreement and who created the CC&Rs. I think there is the degree of scrutiny that implies is that they have to be fair on the unconscionable standard. For example, an agreement that says this goes to arbitration at a neutral forum, but all Chapter 40 rights and remedies remain in effect. That might be enforceable. It's right there. But that's not these agreements.
But let me ask you this. Again, going back to the question I asked earlier, you're assuming the arbitrator isn't going to enforce the Chapter 40 provisions. Have you had a case that's gone to arbitration where an arbitrator hasn't applied Chapter 40?
Not one of our cases has gone to arbitration at all in the last 13 years. Why is that? It's not because they didn't put it in their CC&Rs. They didn't put it in the purchase and sale agreements. It's because until Lamar decided about 3 years ago to revisit the Birch and Green and Gonski line of cases, other developers have simply said, no, we're not going to ask for that. So they have not gone to arbitrate. We have no track record even though we handle a lot of these cases. But the risk, again, is, for example, in the CC&Rs that Mr. King mentioned, where it says all the arbitrator is authorized to provide all recognized remedies available in law and equity. But in that one section, early on it says if there's any disagreement between the CC&Rs and state law ordinance, the CC&Rs apply. So it basically gives with one hand, takes with the other. And it does that repeatedly. This CC&Rs, in this case, section 25, has 4 different definitions of what a construction defect. I'm not just talking about confusing causes. What is the substantive violation that can lead to recovery? There are 4 different definitions, including definitions that excise express warranties and written warranties out of the process. So that's part of the confusion. It's part of the creation of a document that is intended to frustrate the prosecution of these kinds of claims. And that's what I think should be considered as well. It changes the definition of defects. It changes the allowable damages. It changes the recovery of fees and costs. It changes the recovery of interest and loss of use. And the reason I start to go through this is it goes back to the court's decision. Do we simply say, is it unconscionable? and we're not going to enforce it because they overreached, tried too many of these things? Or do they say, okay, there's a severance clause. Let's try to interpret this in a way that becomes conscionable. Well, what does the court have to do? It has to eliminate the things that take away damages, take away recoveries, and then it has to add on terms, like if the developer does repairs, they have to provide a copy of what they did so that the homeowner can give that to the next buyer. There are other kinds of things that the court would be asked to not only strike as unconscionable, but add to make it conscionable. I think that's asking too much. And I think if Lennar had the choice when they create these documents to make it simple, if all they wanted was a pure form shift, like Pinnacle says, where all remedies are preserved, it's a pure shift in form. Like the AT&T Conception case says, all remedies remain with the phone subscriber. It was but no class actions. It was a pure form shift. If that's what they wanted, they could have said that. They could have said that. They chose not to. They chose to give us pages and pages of changes between the Chapter 40 rights and what's supposed to apply here. And that's what I think goes to the one-sidedness of the document. Throughout this, there is nothing in here that favors the homeowners compared to Chapter 40. Not one thing. And I think that goes to the one-sidedness as an attempt to make it more difficult to prosecute these claims. Nothing further. Thank you.
Thank you, Mr. King. Mr. King, rebuttal.
Okay, I promise not to take my 9 minutes. I think Mr. Shinnick's comment that not one case has gone to arbitration is Exhibit A of the hostility that we have in the district courts in Nevada towards arbitration. Cases don't go to arbitration because the courts just will not award it. And my client is trying to change that, absolutely. Let me just read one more provision from the CC&Rs. I keep hearing from Mr. Shinnick that we're trying to avoid Chapter 40. The CC&Rs in all caps say, this is important, this is in the arbitration provision, 25.3, subsection B, middle of the paragraph. The provisions of this section are intended to be binding upon claimant and declarant for all claims regulated by the Construction Defect Act. After all the requirements of NRS 40.645 to 40.675 for resolution of the dispute prior to commencement of the civil action. It states it as clear as he keeps saying, why don't they just state it? It states it. It states that you have to comply with Chapter 40, and after you've complied with Chapter 40, then you go to arbitration. It couldn't be any more clear than what's already in there.
Is counsel correct in terms of his recitation that a number of the key terms are in fact different in the CC&Rs than in Chapter 40? I
don't believe he is. And one tactic that counsel does, and I respect Mr. Shinnick, but he's not focused on the arbitration agreement. He's looking at provisions prior to the arbitration agreement that are not being enforced, that are not at issue in this case. Some of these provisions may have right to cure provisions that were set aside as we went through the Chapter 40 process. So I'm not quite sure where he's getting this definition of construction defect. I know it's not in the arbitration provision, which we're looking to enforce in this agreement. We keep looking at other provisions to try and make it much more onerous and much more convoluted than this clear arbitration agreement already is. And that's all I have. Thank you very much.
Court thanks Mr. King and Mr. Shinnick in both cases for your excellent arguments and briefs in this matter. Just as 68810 is submitted, so is 68769 submitted. Also, Justice Stiglitz, who will participate in this, she'll listen to the arguments in both cases. Thank you very much, and we'll be in recess till 11:30.